Good afternoon, everybody, or good morning. Sorry, good afternoon, everybody, or good morning, depending on where in the world you're joining us from. You're all very welcome to today's webinar, where we're going to be talking about the EU's recently revised Product Liability Directive. This directive is going to reform the product liability landscape, and our goal today will be to hopefully help you understand what will be changing in the area and the impact this is going to have on the life sciences industry. For those of you who don't know me, my name is Michaela Herron and I'm Head of Life Sciences and I'm a partner in the products team here at Mason Hayes & Curran. I'm going to be moderating today's session and I'm delighted to be joined by my colleagues for what we hope will be an interesting discussion. So I've got Jamie Gallagher, who's a partner in our products team, and I'm also joined by Aisling Morrow, who's a senior associate in our products team. Moving on to the agenda. So we have quite a lot to get through today and we're aiming to present for about 45 minutes, which will hopefully allow around 10 to 15 minutes for questions at the end of the session. If you have a question during the webinar, please pop it into the Q&A box at the bottom of the screen, and we'll do our best to get through as many of those as possible towards the end. So by way of overview, today we'll be speaking to you about, firstly, the old law, so the old Product Liability Directive back from 1985, and we'll be explaining why reform is required in the current landscape. We'll then move on to the key changes brought about by the new Product Liability Directive in further detail. And we're going to spend some time looking at particular changes in relation to definitions, scope, and presumptions. We're then going to use a software medical device as a case study to demonstrate some of those changes and to try and bring that all to life. Following that, we'll be setting out what these developments mean for organisations operating in the life sciences sector and hopefully offer some practical information for navigating these changes. And then finally, before we conclude with our Q&A, we'll briefly touch on the now withdrawn AI Liability Directive, just to update you in relation to that. So without further ado, I'll hand over to Aisling, please, who's going to kick us off with the original Product Liability Directive with some background. Thanks, Aisling.
Thanks, Michaela, and welcome to everyone who's joining us today. So just in terms of background, before looking at the changes brought about by the revised Product Liability Directive, I want to speak about the original Product Liability Directive and discuss why the reform was considered necessary. So the old directive came into force 40 years ago. It established an EU-wide system of product liability or strict liability for product liability claims. And that means that there's no requirement for a claimant to prove that a defendant producer was negligent or at fault. Of course, the landscape since then has evolved significantly, and historically, the concept of product safety and liability used to be confined to physical products, but now that term encompasses much wider concepts, including software, AI systems, mobile apps, hardware products that are integrated with software, and IoT-connected products. So a 2018 review by the European Commission found that the old directive was in need of reform to meet the challenges presented by digital technologies and artificial intelligence, as well as other liability issues that arise from circular economy business models and global value chains. So if you could turn now to the next slide, please. So in terms then of the new Product Liability Directive, these reforms are achieved in that context. The directive was adopted in March 24 by the European Parliament. It was then formally adopted by the European Council in October 24, and it entered into force last December. Member states must transpose it into their national law by the 9th of December 2026. So it's quite a short transitional period. One of the key functions of the revised directive is to close existing gaps in liability under the old regime that were identified in the Commission's 2018 report. However, the original directive will continue to apply to products which have entered into the market before the 9th of December 2026. And so in that way, it will remain relevant and applicable for years to come. And we're going to see a twin track essentially for a number of years where we'll have claims under the old directive and under the revised directive. And on that note, it's also worth noting that the body of EU case law that interprets the old directive will continue to develop, and it will have implications for the interpretation of the revised directive too. One recent case of interest is the Ford Italia case, which delivered an important decision on the interpretation of what constitutes a producer under the old directive and the circumstances in which a supplier may be held liable as a producer. So, for those operating in the life sciences sector, particularly manufacturers and providers of innovative technology, these reforms mark a critical shift and it may impact on their liability exposure going forward. So, it's important to be aware of the key reforms that are being introduced by the revised directive. And so, on that note, then we'll turn to the next slide and just take a look at some of those reforms in more detail. So, Jamie and I are going to take you through some of these. I'm going to first of all look at the expansion of certain definitions under the directive, more particularly the expansion of the concept of product, the assessment of defectiveness, and the extension of the scope of damage. And then if we could turn to the next slide, please. We're going to look at the extension of liability in terms of the revisions that have been made to the statutory defences, the expanded pool of economic operators that may be held liable as defendants, and other liability issues arising from circular economy models, related services that are integrated or interconnected with physical products, and the business models arising with non-EU manufacturers. And then on the last slide, in this context, Jamie is going to bring you through some of the procedural reforms, going to look at discovery and the introduction of a discovery model, rebuttable presumptions on defect and causation, and then the implications of the representative actions directive. So if we could turn then to the next slide, please, and we're going to start with the definitions. And so there have been a number of reforms in this regard onto the revised directive. The first being the expansion of the concept of product. So essentially what the revised directive has done is extended the strict liability scope to cover software and digital products. So under the old directive, a more traditional view was taken, mostly confined to physical products. And the degree of the old directive's application to software was uncertain, but the general consensus was that it applied to software that was embedded in a physical product. And the result was that standalone or digital only software typically fell outside the scope of the regime. This is confirmed in a 2021 decision by the European Courts of Justice in Crone. This held that mistaken advice in a newspaper could not be considered a defective product for the purpose of the old directive. And it made clear that there was a need for reform on the definition of product, particularly for digital and intangible goods. So this gap has been addressed under the revised directive. It has expanded the definition of a product to explicitly include software, including standalone software and digital manufacturing files. And it also makes clear that software is a product, regardless of how it is supplied or used and whether it is stored on a device or how it's accessed, including through like a communication network or cloud technology, or whether it's supplied through a software as a service model. So while the term software itself is not defined in the revised directive, the recitals to the directive make clear that it applies to software of all kinds. So that includes operating systems, firmware, computer programs, applications, and AI systems. This is subject to a number of very limited exceptions, really, including pure information like software source code and free and open source software that isn't developed or used as part of a commercial activity. So this wider definition of what is considered a product is going to expand the scope of liability for software products beyond those that are incorporated into a physical good. And as a result, it's going to have far-reaching consequences for software developers in all industries, but particularly in the life sciences industry. So it's going to mean that medical apps, AI-based diagnostic tools, and software-dependent medical devices could all give rise to claims under the revised directive. So if we could turn now to the next slide, please, and we're going to look at the next revised definition, and that is the assessment of defectiveness. So under the old directive, Article 6 provided that a product is defective when it doesn't provide the safety that a person is entitled to expect, taking all circumstances into account. And this is by reference to a number of non-exhaustive factors that are stated in the old directive, including a product's presentation, its reasonably expected use, and the time it is put into circulation. So a number of new factors have been added to this definition under the revised directive, and these include a device's cybersecurity vulnerabilities, self-learning functionality, and interconnectedness. And in terms of real-life application for the life sciences industry, these factors can be used to assess the defectiveness of a range of medical devices. For example, a smart insulin pump that may communicate wirelessly with a continuous glucose monitor and a smartphone app. So it's definitely, it's a very important reform under the revised directive. And then lastly, as you can see on that slide, there has been a change to the scope of what constitutes damage under the revised directive. So under the old directive, damage refers to physical injury or death, as well as damage to property, provided it's not the actual defective product itself and it's intended for private use. And this property damage was subject to a €500 minimum threshold, below which claims were not recoverable or actionable. So the revised directive extends the definition of damage beyond these two to include medically recognised psychological harm and damage from loss or corruption of data, provided that it's not for professional purposes. And as a result, a product may be considered defective even in the absence of a physical injury. For example, when using a defective product causes somebody severe anxiety or stress. The minimum financial threshold has also been removed for property damage claims, and this is going to make it easier for claimants to seek compensation for smaller amounts of damage. So these reforms have particular implications for software developers and manufacturers of complex and software-driven products. In a more general sense, claimants can sue for a wider range of damage, particularly where there is no minimum threshold limit. And this could materialise in more claims, including for loss or corruption of data, which may arise through avenues including inadequate software updates or insufficient cybersecurity protections. So these are all coupled together. They're all going to likely lead to an increased liability exposure and increased legal costs given the complexity of the new regime. So if we could move on from that now to the next slide, and we're going to look at the extension of the scope of liability under the revised directive. So I'm going to look at, in the first instance, at defences. And so the statutory defences under the old and new directive, if successfully invoked, allow a defendant to avoid liability entirely. There are 6 statutory defences under the old directive, and some of these have been subject to reform under the revised directive. So I'm going to look at 2 in particular, the state-of-the-art defence and defects emerging after a product is placed into circulation. So under the old directive, the original manufacturer could escape liability for product defects that emerge after a product is put into circulation. Under the revised directive, this concept of putting a product into circulation has been replaced with the concept of placing on the market and putting into service. And this aligns with these concepts in other EU product safety legislation. In addition, the scope of liability is extended to the time after a product is placed on the market, where it remains under the manufacturer's control. So in practical terms, this may apply where a product becomes defective while it's still under the manufacturer's control due to a range of factors, including a related service, software, including software updates and upgrades, or the corollary of that, a lack of software updates or upgrades that are necessary to maintain the product's safety, or a substantial modification of the product. So as an example, in that context, where a product has been substantially updated or modified through software updates, and this would be particularly significant for connected devices, where a hardware manufacturer retains the ability to supply software updates and upgrades to the hardware by itself or through a third party. And because of these new provisions, manufacturers of medical device products with digital elements may be liable for damage arising from changes to the digital elements and components of their physical product after that product has been placed on the market. Second, then, another key statutory defence is the state-of-the-art defence. And under this defence, under the old directive, a defendant can avoid liability if they can show the defect was not discoverable due to the state of scientific and technical knowledge when it was put on the market, or sorry, put into circulation. So the revised directive amends this defence to include the time after the product has been put on the market, provided that it's under the manufacturer's control. So another key reform under this defence as well is that member states can derogate from the inclusion of this state-of-the-art defence in their national laws. So in those circumstances, an economic operator could still be held liable even if they could successfully invoke the state-of-the-art defence if ultimately a member state has decided against including it on their statute books. And then lastly, there are limitation periods that may provide a defence as well under the strict liability regime. Under the old directive, a limitation period of 3 years applies within which a claimant must bring a claim or else they will be statute barred. And this is subject to a long stop provision where a claimant's right of action is extinguished 10 years after the product has been put into circulation if they haven't brought a claim in the meantime. And under the revised directive, that 3 year limitation period remains, but it contains, there are two modifications to the long stop or the expiry period, as it's now called. The first is an extension from 10 years to 25 years in the case of latent personal injuries that only become discoverable at a later date, unless the injured person has brought proceedings in the meantime. And the second modification is where a product has been substantially modified. And in those circumstances, effectively the clock starts again from the date that the substantially modified product has been put on the market or placed on the market or put into service, essentially acknowledging that it's a new product. And so they're very important points to note. So if we could turn now to the next slide. A couple of other issues we're going to look at under the extension of liability heading. The first being the circular economy. So values of reuse, repair, refurbishment and remanufacturing are growing in importance as we become more environmentally conscious. The revised directive has addressed the shift by the introduction of new rules which will govern liability in the case of modified products. So where a product has been substantially modified and then made available on the market or put into service, it is considered a new product, as we've just mentioned. And where the modification is made outside of the control of the original manufacturer, then the person that made the substantial modification is liable as the manufacturer of that modified product. And this again aligns with relevant EU product safety legislation that holds that such a person responsible for the modified product's compliance with product safety legislation. So when a modification is substantial, it'll be determined by reference to criteria in EU and member state legislation, including the EU General Product Safety Regulation. And where that criteria doesn't exist, a modification will be considered substantial where it changes the product's original intended function or affects its compliance with relevant safety requirements or changes its risk profile. If a substantial modification is made by the original manufacturer or under its control, including by a third party, then the modification makes the product defective, then the manufacturer remains liable. But a party other than an original manufacturer that makes a substantial modification can avoid liability if they can show the damage is not related to the modification itself. And the revised directive also holds that economic operators that provide repairs and other non-substantial modifications to a product should not be held liable. If we could turn then to the next slide, please, and we're going to take a quick look at, if we could keep on that slide, I beg your pardon, I'm just going to touch very briefly on defendants, I won't take very long. The revised directive expands the pool of economic operators that can be held liable for a defective product. So in addition to what we have under the old directive, manufacturers, importers and distributors, we also have the providers of related services, authorised representatives, fulfilment service providers, third parties that make substantial modifications to products already on the market, and online platforms where they play more than a mere intermediary role in the sale of a product. So these expanded definitions are designed to make sure there's always an EU-based person that can be held liable. So if you could turn now to the next slide, please, and we're just going to take a quick look at related services. So the inclusion of related service providers under the pool of economic operators that can be held liable is particularly important to the life sciences sector. The revised directive defines a related service as a digital service integrated into or interconnected with a product in such a way that its absence would prevent the product, from performing one or more of its functions. So whether a related service and its components, including software updates and upgrades, are under a manufacturer's control is fact sensitive. They are considered under the manufacturer's control when they are integrated or interconnected with a product by the manufacturer or by a third party with the manufacturer's consent. A manufacturer won't have consented simply because integration or connection is technically possible, or because they've recommended certain brands, or because they haven't explicitly prohibited related services or components. And many medical devices now use and rely on cloud-based platforms, AI-driven analytics, and app integrations to deliver remote patient monitoring in real time. And so the revised directive is cognizant of this and includes, as an example of a related service, a health monitoring service that relies on a physical product sensors to track users' physical activity or health metrics. So as a result, related service providers that may previously have considered themselves outside the scope of strict product liability laws now have a potential liability exposure if their service contributes to a product's defect and ultimately to any harm that may be caused to the end user. So on that note, I'm going to hand over to Jamie, and he's going to look at changes to the substantive procedural aspects of proceedings under the revised directive.
Thanks, Aisling. Hi, everyone. Take the next slide, please. Thanks. So firstly, in terms of procedure, the new directive introduces a new set of disclosure of evidence provisions at Article 9 that have the potential to bring about pretty significant changes in various EU member states with civil law systems, where up until now, disclosure obligations have been relatively speaking focused or narrow, at least by comparison to common law systems of discovery that we would have here in Ireland, for instance, and elsewhere in the UK and the US. So under this new EU, harmonized EU discovery model, there's going to be a need for national mechanisms to be put in place that will require defendants to disclose what is termed relevant evidence once the claimant presents facts and evidence to support what is termed in the legislation as a plausible claim. So as I've alluded to already, those of us in Ireland with our common law system are unlikely to register this as much of an impact, given our existing discovery processes, which are often hard-fought, protracted, burdensome, and generally very costly as a phase of product liability litigation, that are also characterized by things like contested court hearings and judicial orders. However, a reading of Article 9 does seem to suggest that those types of processes that we see in common law systems may now become a more prominent feature of product liability litigation across the EU in civil law systems as well. How national courts are going to provide for the criteria around that plausibility threshold that the applicant will need to satisfy, as well as what amounts to relevant evidence that needs to then be shared, is also going to be a really important battleground, given the potential for these new mechanisms to be used by claimants to obtain information and evidence in support of their cases that would otherwise be unavailable to them under the existing system. So just to point out as well that defendant manufacturers will have a corresponding right to request disclosure of claimants. And a classic example of that in the Irish context, at least, would be seeking plaintiff medical records where the damage alleged is a form of personal injury. So it is a two-way street to some extent. And as another means of providing some comfort, perhaps, there are reference to the need for proportionality and measures for the protection of trade secrets, although we know that in practice, such measures can be difficult to agree and get in place, and then costly to administer in practice, and with mixed results ultimately. So we would expect this to become a particularly sensitive part of the litigation process, particularly when it comes to innovative medicines, medical devices, and IVDs. Finally, just to flag under the heading of disclosure obligations, the possible need for the disclosing party to present evidence required in an easily accessible and understandable manner, which sounds like a potentially quite costly layer to the disclosure obligation, which is more likely to be borne by defendant manufacturers in cases involving technologically sophisticated and particularly innovative products. That's a category that, again, medicines, medical devices, and IVDs would likely fall squarely within. If we take the next slide, please, I'd like to talk about rebuttable presumptions. These are presumptions of not only defectiveness of a product, but also the causal link between the defect and the alleged damage suffered. So these are another new measure which has been included in the revised directive. that are designed to support basically the claimant in cases involving technologically sophisticated products where a sort of asymmetry has been identified in terms of the relative understanding of the parties, the claimant and the defendant manufacturer, in terms of how a product works and what exactly may have gone wrong to cause the damage of complained of. So a good example here in a 21st century context would be the so-called black box AI system, appearing in a life sciences context. That could be as part of a particularly sophisticated software medical device, for instance. Aside from software, you could also look at products with particularly complex manufacturing processes, such as ATMPs, for instance. Article 10 of the new directive is worth a read, and that's where you'll find the provisions providing for these rebuttable presumptions. But for present purposes, I think it's important to note that national courts, in our view at least, are going to have their work cut out for them in terms of working out how to interpret some of the legal tests that are going to dictate how and when these rebuttable presumptions will trigger in practice in actual cases. So, for example, defectiveness under the new directive can be presumed, and that'll be by a function of a court order, where the claimant can point to what's been termed an obvious malfunction of the product. Defectiveness could also be presumed where the product has been shown to be non-compliant with product safety legislation, which is intended to safeguard against the damage suffered. So there we see this ever closer link developing between product safety compliance and product liability, to the extent now that non-compliance with safety requirements, and I'm thinking here, for example, of excuse me, the MDR, the IVDR, any number of medicinal product safety frameworks, or even the General Product Safety Regulation or the AI Act, where relevant to life sciences products, where breaches with those frameworks could in and of themselves effectively serve as a proof as part of a product liability claim, at least insofar as establishing a defect is concerned. There is a rebuttable presumption of causation then, and the test there will be where the claimant can show that the damage caused is of a kind typically consistent with the defect in question. So still, until we get national court decisions, quite a lot of uncertainty as to what typically consistent, how it will be interpreted. And then either or both defectiveness and causation can be presumed. And all these presumptions operate even where disclosure has already been given. But either defectiveness or causation can be presumed where the claimant can show that they face what is termed in the directive excessive difficulties, particularly with reference to the technical or scientific complexity of the product, in a way that's likely, where it's likely that the product is defective or the causative relationship with the damage exists. So again, quite a low threshold of just likely there. So practically speaking, this raises the spectre of having to potentially defend a case about an obvious malfunction in a product, leading to damage that is typically consistent with that malfunction, which on its face would seem to place a lot of pressure back on defendants. The rebuttable nature of the presumptions also links back to disclosure, in that defendants may end up having to disclose and present significant amounts of information about sophisticated and innovative products in order to defend a claim about them. So I suppose to wrap up, viewed in one way, these new procedural mechanisms, these rebuttable presumptions, could be viewed as sort of a legislative codification of principles established in existing ECJ case law. I'm thinking here of cases like Boston Scientific and Sanofi Pasteur. However, they are, I suppose, the provisions, and more importantly, how they'll be applied and interpreted, do seem like they're going to require a new wave of national and probably European Court of Justice decisions, and a corresponding period of uncertainty while we all work out how these changes are going to impact on cases from that procedural perspective. Although it does seem like these mechanisms are going to add a layer of complexity and cost for both sides, notwithstanding the intention to level the playing field for claimants in certain cases. If we take the next slide, please. I want to touch briefly on collective redress and group claims. At the moment, only the old Product Liability Directive is scheduled to the Collective Redress Directive. I'll call it the CRD for short as part of this segment. But we do expect the revised directive to be added in due course. I've already mentioned how in certain jurisdictions like Ireland, the disclosure of evidence provisions may have less of an impact. But that being said, collective redress in the context of product liability claims are a much more significant development in jurisdictions like Ireland that don't have a group litigation or a class action process, and even also strict prohibitions on litigation funding, for instance. So in those types of jurisdictions, such as Ireland, the collective redress mechanism provided for under the CRD does give rise to a potentially very significant procedural development in the product liability context, especially when we take that and view it in combination with things like the expansion of the concept of defect that Aisling's already covered, and the ability of what are termed qualified entities to bring claims in what could be relatively what you could term low-grade damage, albeit suffered by a large group of consumers. And those claims would be taken essentially on public interest grounds and in circumstances where those impacted consumers may not have otherwise have been motivated to associate and organise with a view to bringing a test case, for instance. So if we take the next slide, please, we're going to, just as a means of trying to bring this to life, a lot of concepts and sort of abstract material there, we thought we might look to use a hypothetical case study involving a fictional standalone software medical device, which is something that wouldn't have historically been subject to a claim under the old directive. And we want to try and use that to illustrate some of the features of the revised directive that we've just been speaking about. So we decided to go with this fertility tracking app, which would be, or is in this case, an MDR Class 1 device. It's intended to support conception by calculating the user's fertility status, and it's sort of operates on a validated statistical algorithm. So you can picture an app here where the user inputs health data, including things like basal body temperature and menstruation days, and the app tracks and predicts ovulation with the fertility status the current day reflected by perhaps a color coding system, red fertile, green infertile, or yellow learning phase, or sort of a cycle fluctuation indicator. So in our scenario involving this hypothetical device, there is an incident and one or more users are shown dates that are clearly incorrect. And added to this, there's a bug in the software that ends up resulting in irretrievable loss of a group of users' personal data. So we're going to try and just go quickly down through the various headings that we've been covering. And Aisling, with that, we might take that definition of product first, and just looking at this particular product, asking, are we within the scope of the new directive?
Yes, first of all, apologies. I think my sound isn't particularly good this afternoon on my computer, so apologies for that. In answer to your question, Jamie, yes, software is specifically included under the revised directives, so a product of this nature would be within scope.
Great. So we're in scope of a claim. Taking defect, then, would an incident like this point to a defect under the revised directive?
Arguably, it could. The standard for assessing defectiveness is where a product doesn't provide the safety that a person is entitled to expect or that is required under EU or national law. This is by reference to a range of criteria, including its reasonably foreseeable use and the specific needs of the group of users that it is intended for. So, based on criteria like this, it's arguable a plaintiff could make a claim on that basis.
Okay, okay. And then damage was something else we covered. Um, how would we apply that here, given that we aren't necessarily dealing with sort of a classic physical injury case?
Exactly. Yeah. So in this case, the algorithm has effectively misfired. The user has lost an opportunity to conceive because the fertility dates were wrong. And in addition, the user's data was destroyed. So under the revised directive, as we've spoken about, destruction of data and medically recognized physical or psychological harm are now within scope. So it's no longer just limited to damages for physical injuries and property damage. So arguably, a user who has suffered psychological injury because of this incident and or has also that they have a claim for destruction or loss of their data. So yes, it would be actionable.
Okay, well, we might touch on causation in a minute, but for the time being, I think the message is that the ingredients of a statable claim under the directive, the revised directive, seem to be there, arguably. But do any defences jump out?
Yeah, so in terms of the statutory defences, one possible one that jumps out is the state-of-the-art defence. If successfully invoked, a developer can avoid liability for a defective product if they can show that the state of scientific and technical knowledge at the time the product was put on the market or put into service or the period after that, so long as it's under the manufacturer's control, prevented the detection of the defect. But there's a number of sticking points with this. That additional period after the product is on the market is a hindrance, as are the fact that the defence, we're not entirely sure actually whether member states are going to derogate from this defence, and so it may not actually be open to developers in every member state, and there's no clarity on that for the time being. So it's not entirely clear what defences might be available, but that's a possibility.
Okay, great. Thanks, Aisling. And so just to cover some of the procedural features that I was talking about earlier, in terms of discovery or disclosure of evidence, and in the context of a software product like this that is allegedly malfunctioned, the danger is that a court would find that this so-termed plausible claim has been made out here, and that the evidence that is then relevant and disclosable on that basis makes up quite a broad category of disclosure that's likely to include, for instance, a detailed breakdown of the inner workings of the app, which is obviously information that's prone to being quite commercially sensitive. As well as that, there is that part of the new directive that talks about presenting the disclosable information in an accessible manner. So for a technically complicated product like this, there could then be this added layer of work for a defendant manufacturer to then have to go and structure what could be quite a lot of that sensitive information in a way that renders it accessible and understandable to the claimant. On the rebuttable presumptions, just to bring that to life, in terms of the presumption of defect, the problem here involving giving incorrect readouts, if they're clearly incorrect, may well be found to be an obvious malfunction of the type that could trigger a rebuttable presumption of defect. On the presumption of causation then, you could take damage like the type of irretrievable data loss we'd be talking about here as something that could be found by a court excuse me, to be typically consistent with a defect like a software bug that's at issue here. So that's a good example of how the the presumption of causation threshold to trigger that rebuttable presumption could actually fall quite low in certain factual scenarios. And on the presumption of both defect and causation, that can trigger where the plaintiff can show they would face excessive difficulties in making out their claim, given the technical sophistication of the product. And again, a standalone software app, to our minds, would be a good example of where a court could go with a claimant and find that presumptions of defect as well as causation could both be appropriate to apply. Finally, just and briefly on collective redress, these types of defects and damage arising in a software app are not, in Ireland at least, typically the kind of incident that might warrant a single user independently seeking legal advice in order to launch a claim. However, similar in a way to things like data breaches, in the sense that malfunctions impacting software tend to happen at scale, an incident like this may leave a relatively large group of disaffected users who could end up being represented by a qualified entity, bringing a group claim under the Product Liability Directive and the revised directive once scheduled to the Collective Redress Directive. And that would effectively be on public interest grounds, which is a legal risk that software developers, especially, may not previously have had to worry about before the CRD came into effect. We just move on now and look at the impact on life sciences companies in a bit more detail. I think the first thing to say here is that by their nature, the products developed by life sciences stakeholders, be they drugs, devices, or IVDs, are highly sophisticated and innovative inherently. And added to this, they're also increasingly digital. So the new directive gives life sciences companies a lot to think about. At a high level, claimants are now going to have more legal mechanisms and procedural tools to use in order to prosecute their claims, their product liability claims, to a successful conclusion from their point of view. And on the ground or in court, those mechanisms and tools are going to have the potential to add another layer of legal complexity to product liability litigation in the EU. And that can and likely will result in an increased risk to businesses in terms of both the costs of assessing and mitigating liability exposure in the first instance, and then as well defending claims where they ultimately arise. You can take that and sort of break it down under a few headings. First is expanded liability. So it's really important that life sciences companies who are involved in developing medical software or products integrating AI understand that these digital technologies are going to be scoped in using that broader definition of product. And as we mentioned earlier, damage now will extend and is extending to the loss or corruption of data. So in light of that, life sciences companies need to start thinking about their digital services as potential components of their regulated products from a product liability perspective. Second up is ongoing control. The extension of liability for defects that can now arise after a product is put into circulation, if it remains under the manufacturer's control, is a notable development. Particular example here would be the medical device company manufacturing a connected device, such as a smart insulin pump or an implantable device like a pacemaker, supported by a proprietary or even third-party software. So those types of companies need to think about implementing more sophisticated and longer-term management and monitoring strategies with reference to product liability litigation risk exposure. And thirdly, I just want to mention the evidentiary thresholds. The introduction of the rebuttable presumptions in cases that are going to involve complex technology, excuse me, they have the potential to make it easier for claimants to win their case. And that's even where defect or causation cannot be definitively illustrated. And so those presumptions are likely to operate to the detriment of life sciences companies in particular, in our view. And combined with those new disclosure of evidence rules, they are going to potentially and likely make the management of sensitive information about innovative products as part of your product liability litigation processes even more pressing as a consideration. If we take the next slide, please, that sort of drops down into some more practical steps. What practical steps can life sciences stakeholders take to prepare for the coming into effect of the new regime? Well, firstly, because of the changes to what products are now going to be in scope of a claim, most notably standalone software, stakeholders need to reassess what parts of their portfolio now carry product liability exposure risks. That could include a consideration of where things like related services and substantial modification, which are again particularly important in the context of software products, are now going to play a role. Arising from that, there may be further work that can be done with reference to the now expanded concept of damage. So, for example, do warnings and disclaimers need to be added to certain products that are now within scope of the new regime? And do those warnings and disclaimers that are already there need to be updated to account for new forms of damage, such as corruption or loss of data? A third step could involve a review of product liability insurance cover to make sure that that cover aligns with the risk profile of the portfolio under the new regime. And finally, another practical step could involve looking at contractual arrangements that you have with commercial partners who are involved in the manufacture, supply, and on-market support of products as well. And that's with a view to ensuring that there are adequate liability and indemnity provisions in place. And that's particularly important given that, again, you have these new provisions around service providers and what's considered to be within the manufacturer's control, even if a third party is carrying out certain tasks or services on the manufacturer's behalf. So we're nearly at the end, and Q&A, just very quickly to cover on the next slide, the proposal now withdrawn for an AI liability directive. This proposal aimed to revise and more accurately harmonize the fault-based rules for claims arising from injuries caused by AI systems. That was as a supplement to the revision of the no-fault strict liability system provided for under the revised directive. In practice, that would have prevented national fragmentation of fault-based liability rules in cases involving damage caused by AI systems. So just like the Product Liability Directive, the AI Liability Directive had been intended to introduce reforms like on things like disclosure requirements and rebuttable presumptions that would have been transposed in parallel into national civil procedure rules. And then together with the Product Liability Directive and indeed the AI Act on the product safety side, that set of legislation would have harmonized how AI systems were treated under these headings of fault-based strict liability, as well as product safety. This proposal for an AI liability directive was withdrawn by the European Commission in February of this year. There was a lack of agreement among stakeholders cited as the main reason. However, just to note, that February announcement suggested that a similar piece of revised legislation could be put forward in the future. So we shouldn't consider the withdrawal of this proposal on the fault-based liability side to be the end of the idea of a framework like the AI Liability Directive. So watch this space on the fault-based liability front. And with that, I think we're going to move back to Michaela and some Q&A.
Thanks, Jamie. So from our discussion today, we hope that we've helped you to understand the impact of the revised PLD and what that impact will have specifically on the life sciences sector. We also hope that the practical information that we've shared will be useful in helping you to achieve a better understanding of minimizing risk in light of the revised PLD. There have been some questions coming in, so let me just take one. So firstly, Okay, for the disclosure requirements, can claimants seek this pre-proceedings? Jamie, is that one you can take?
Yes, I'd answer that by sort of comparing the revised directive and the AI liability directive. The revised directive that's adopted, and we're looking at it here on the strict liability side, doesn't make provision for pre-trial or pre-proceeding disclosure obligations. And indeed, the Article 9 that I mentioned, it says that those provisions don't affect national rules affecting pre-trial disclosure where they exist. So no, unless a national procedure provides for it. And just to note, the AI liability directive proposal that was withdrawn by distinction did refer or allude to the idea that the disclosure obligations under that in that sphere there would have been a pre-trial element to them. But as we know, that is now off the table, and that might be adjusted in whatever revised proposal comes out.
Okay. What impact might the revised directive have on damages awards and on legal costs? Aisling, is that one for you, please?
Yeah, thanks, Michaela. So there mightn't be any significant shift on the level of awards in individual cases. Irish courts already make awards in respect of psychological injury and in respect of data breaches. But a number of the reforms under the revised directive, when they're coupled together, could result in a higher volume of cases. So, for example, bringing software within scope, expanding the types of damage that people can bring a claim for, removing the minimum financial threshold, and expanding the pool of economic operators that can be held liable. So when you put all of those together, and also with the potential for collective consumer redress under the Representative Actions Directive that Jamie touched on, there's a potential for an increase in litigation more generally, and this is going to lead to a greater financial exposure for a range of economic operators, specifically manufacturers and software developers. So this is going to result in more legal costs, because we're going to be potentially addressing more legal claims. There's potentially going to be also an increase in legal costs because we're dealing with a complex new regime, and while we're getting to grips with those reforms until a new body of case law develops under the revised directive. So I think for all of those reasons, these reforms are going to result in more claims, increased legal costs, but it remains unclear yet if it's really going to impact on the kinds of damages. They could be lower cost claim or lower value claims, maybe a greater number of them.
That makes sense. Thank you. One more question. So what is the transposition status of the revised framework? Jamie, could you take that, please?
Yeah, sure. So it was adopted in December. Member states have until December 2026. The last update I saw was that we have so far only the one, no, it's only April, or rather May now, the one member state, which is the Netherlands, that has published a bill back in April. And then there are signs of sort of pre-legislative work. I've seen some reference to Finland and Sweden doing sort of working groups or special rapporteurs or what have you. Here in Ireland, there's been some reference to work underway, but nothing, I think, published yet. I will say, so not a huge amount of movement, I suppose, official, publicly viewable movement at the minute. I think it is going to take a lot of work, though, in a lot of jurisdictions to provide for some of the procedural, what are going to be new procedural elements when you think of the rules of court in Ireland and the level of granularity that you actually need to provide for to make this workable in court and all these different systems. So there's doubtless a lot of work required to get it up and running. December 2026 doesn't actually give member states a lot of time, I suppose, and it's going to be done in all sorts of different ways. And the national legislation will effectively come online at different stages. So that goes back to Aisling's point that we're going to be dealing with sort of different regimes getting up and running in different jurisdictions. There'll be sort of a transitional phase where things will be potentially get quite complicated if you're doing a multi-jurisdictional sort of group litigation. And just to close on Ireland, we have a 1991 Liability for Defective Products Act. In practice, you might see an amendment to that as opposed to a whole new act, and updates or additions to the rules of superior courts, for instance, but nothing to review or do a consultation on just yet.
Great, thanks. Yeah, December 2026 is pretty soon, so
Yeah.
let's watch this space. That brings us to the end of our presentation today. So just want to say a huge thank you to our speakers, Jamie and Aisling, for all of their insights, and a huge thank you to all of you for attending our webinar. I hope that you found it useful. If you do have any queries or questions, feel free to email the three of us. Our contact details are on the slide. You can find us on the website. And in order to claim your CPD certificate for today, please fill out the questionnaire on how you found today's webinar. Thank you very much and enjoy the rest of your day.